Hey out there, legal warriors, what are the consequences of refusing to take a breath or blood test when you're asked to do so in Washington State? And for this, I'm talking about what you might imagine. You get stopped for investigation of DUI, and what happens if you refuse the test. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington State for more than 25 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like it, please subscribe. More people get to see it. More people get the help they need. Now, this is a question that I get quite often. And the question usually is, should I take the breath test? And that's not a question that I can answer for you because, of course, number one, it's unique. It would be legal advice. I can say what I might do in a situation, but I can't tell you what you should do. So I'm doing this a different way. What are the consequences if you refuse a lawfully requested breath or blood test on a DUI stop in Washington State? Well, the consequences, as you might imagine, can vary, but the primary one is something that derives from what we call the implied consent law. So according to the theory of most DUI laws, including in Washington State, that for the privilege of driving on the public roads of Washington State, the legislature has deemed that we all have impliedly consented to a test of our breath or blood for alcohol or drugs when lawfully and reasonably asked to do so by a police officer. And because we have free will, supposedly, we are allowed to revoke that consent, but the implied consent law in Washington State says if you revoke your consent and refuse that lawfully requested breath or blood test by an officer, then the legislature said, well, we're going to revoke your privilege to drive then. Because remember, we have deemed you by law to have impliedly consented to that test if an officer has reasonable grounds to request it. Not just because you're walking down the street, right? Because they pull you over, they smell alcohol, they think you're affected. And of course, we all, that's what all officers think whenever they get to this. They're not always right. But so if you refuse, the consequence is that you lose your license. And that's a pretty big consequence for refusing. Another consequence of refusal is the prosecution can then say, hey, you refused because you knew the test was going to be bad. You knew you're guilty. Consciousness of guilt for refusing. They can do that. And so how bad is that loss of your license? Well, the good news is that in Washington State, you can also apply for something called a restricted license. That's what Department of Licensing calls it. We might call it an ignition interlock license to drive during a period of suspension. So if you do suffer a suspension, in many cases, you're still going to be able to drive if you follow the rules. To get a restricted license, where you have to have a special type of insurance and an interlock in the car that you're driving, even if it was a blood draw, which is crazy, because of course blood is usually for marijuana, stuff like that, and blow and go isn't testing that. But they write the laws one size fits all around here. So if you refuse and you lose your license, well, you can probably still get a way to drive if you follow the other rules for the Department of Licensing. You need to talk to your attorney about that. So what benefit do you get, right? We said, what are the consequences for refusing? Well, the benefit is now a little bit illusory, which means it's sort of imaginary now for the most part, because more often than not now, if you refuse a breath test, they're going to do a search warrant, the police, to get your blood, okay? Which means they're still going to get a number. Right? And some people would argue the blood's more accurate. I don't really think either are particularly accurate, but remember, this is just sort of a situation where the legislature set up general rules to protect the public, and so certain numbers are automatically illegal, 0.08 for adults, for alcohol. So it used to be if you refused, it was a real unlikelihood that an officer would try to find a judge and write a search warrant and wake them up and do all these things to get a blood draw on a standard DUI. It's just too much work, right? If there's an accident with an injury or a death, yeah, they're going to do all that. But in most cases, I mean, I've been around in the criminal system here for 32 plus years. very rare you'd see a blood draw on a refusal. And so lots of times if someone was really drunk, they'd refuse and they'd have a better defense. So nowadays, though, because of marijuana being legalized and because of the need to test people's blood for marijuana, since there's no breath test for that, then all these processes got streamlined. It's not quite one button punching to get a warrant, but it's pretty close. Templates, judges are more likely to be readily available because of the increased number of warrants for routine traffic matters like this. And so now when you refuse that breath test, you're getting that worse penalty on your license, because suspensions or refusal are usually worse than numbers over the limit. And they're still getting the evidence. And there's a few jurisdictions who will remain nameless here where are less likely to go through the work because just their culture, maybe they don't put in quite as much effort at 2 a.m. as some of the law enforcement agencies. But you can bet dollars to donuts they're probably going to get that blood draw anyway. So the consequences of refusing then are a little more severe because you're getting a potentially longer license suspension. They can potentially use it as consciousness of guilt, and you're not gaining anything anymore because they're still going to get a number. In fact, you might make your situation worse because that blood draw may show other things, right, that wouldn't be in the breath test for alcohol. Also, the typical period of time the state toxicologist is taking to do a blood result is a year. Right? So you might wait with this in the back of your head for a year until they even file the case into court. There are some jurisdictions that will proceed without the blood draw and try to resolve it prior to the blood coming back, but many jurisdictions just won't file the case. Just wait until the blood comes back, which means your life is on hold, right? Your brain is like, I want this done, and it can't be done because they're waiting to get the blood draw back. And how long do they have to file the case? 2 years, right? And many times they'll take the entire 2 years to file the case. Well, if you would have just taken the breath test, right, the case most likely would have started much more quickly, unless there's certain, Snohomish County is going to take forever, regardless if it's a sheriff or state patrol, just because of how long their charging happens to be taking. We'll see if it speeds up. I'm filming this very late in 2025. So what aren't the consequences of refusing, right? Well, you're not supposed to be put in jail because you refused, although an officer may, take that into account if they feel like they're mad about you refusing. You're not automatically guilty because you refuse, right? We can say things in court. There's reasons why we don't trust the machine, plenty of reasons why we don't trust the machine, stuff like that. And so it's not like a death to your case to refuse. Don't worry about it if you chose to refuse and you think you made a mistake, because there's probably not a lot of wrong answers when you're in this bad situation. The biggest thing that we need to do is just shut up, right? Don't admit to drinking. Don't talk about the prescription medications that we happen to be on, things like that. We need to do things to not build their case. But nowadays, if they have reasonable grounds to arrest us, they're probably going to get a result one way or another, whether you refuse or not. But yes, you're allowed to refuse. And there will be a licensing consequence if you do. You'll have a right to request a licensing hearing to fight about that consequence. You've got 7 days typically to do that. You got to pay a fee for that, nowadays $375. And if you watch some of our other videos, sometimes if you get released from the jail, they don't give you the proper paperwork to tell you about that. So if you or your loved one's gotten out of jail or recently got cited for a DUI or stopped for it, contact an attorney immediately, because DUI is one of the few areas where time matters, right? Where there's a hard deadline to request things to protect your license. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you have a criminal matter in Washington State, feel free to reach out to our firm. If we get on board, we'll listen to what happened. We'll identify a way forward. We will be there for you. Thank you.